wonderful introduction, and thank you for having me. It is a privilege to be able to spend time here in Innsbruck and at the Digital Science Center. So I will, as I liked what you said, Clara, that I will reflect on empirical methods and digital tools in legal research. I should say perhaps from the start that my path into empirical research methods has been something of a happy accident, something that I can't really say I walked into confidently and meaningfully, but sort of stumbled across. I've been fortunate to work with some brilliant people, and I've been sort of learning by doing over the last few years. And that's also very much how I would like to look at this presentation, as sort of imparting what I have picked up so far, but also hoping to continue to learn and to discuss this with you. And I'm very much looking forward to your reactions. So, in order to appreciate what digitalization means for legal research, I think we need to establish first something about what legal research traditionally is and what we're coming from as legal scholars, so to speak. So for the lawyers in the audience, I apologize. This is your chance for a couple of minutes to, check your emails or your Twitter accounts or something. So legal research traditionally is a normative science, or we even use the term of dogmatique, so dogma. And sometimes I explain this by saying that we are a little bit like theologists, in that our truth is not a positive truth that is verifiable, objective, or possible to examine with empirical means. Rather, truth is something that is established in a single authoritative document. And it doesn't have to be established repeatedly. It's enough that it has been stated once, even if it was 100 years ago, by a particular authority, like for instance, is the Austrian Constitutional Court, which would be one of those authorities. The legislature, of course, the parliament would be another. So in that sense, we have a very specific concept of what is right or true or valid within legal scholarship. Second question that comes up is what do legal researchers actually do, especially when we speak to natural scientists? Because we don't, of course, have labs or experiments. We generally don't observe or interview. So from a methodological standpoint, legal scholarship is traditionally extremely qualitative, perhaps to be compared with the literary science. So it's a qualitative method to the extent where we don't really even aim for reproducibility. So the person of the researcher is, in a sense, an integral part of the work and forms part of the authority of that work. It's also noted, I think, by a stark attention to detail, and that's a point that I will return to towards the end of this talk. And thirdly, legal research has a strong self-referential element, in that when legal researchers are looking for new knowledge, we're looking, as I said, not to the outside world, but we're looking to our own authoritative documents. And the new knowledge that we seek is generally knowledge about how the law ought to be interpreted. So again, it's a normative knowledge, and it's self-referential in the sense that legal scholars are also part of that system. So by stating that the law ought to be understood in a certain way, we also contribute to making it so. And this, I think, is something that sets legal scholarship aside from a lot of other disciplines. Now, what I think we're seeing in the last few years is what can perhaps be called an empirical turn, where we see legal scholarship that is not normative, qualitative, and self-referential, but rather descriptive, quantitative, and verifiable. That is to say, concerned with the real life functions, effects, expressions of law, rather than merely the theoretical construct. And I mean, I will count myself to this turn, but I should also say that I say this without evaluation. I think there is much to be said for traditional legal research, but I think this is a new and coming perspective that has great possibilities of adding something. And I think one of the most dramatic effects of this is that instead of looking to these singular authoritative texts, scholars in this vein look to empirical materials that are closer to legal practice. So instead of looking to the one interpretation of tax legislation laid down by the Supreme Tax Court back in 1970 something, they might look at what do 1,000 tax agents do when applying the tax law, and there is an underlying claim that practice is also law, even though from a sort of theoretical legal perspective, we might say that, well, if they're doing something else than what the Supreme Court said, they're doing it wrong. So it is, in a sense, challenging our understanding of what law is. And in that vein, that also opens up to new methods and computerized methods. And I wanted to show you a little bit of the work I have been doing the last few years. As Clara mentioned in the introduction, I'm an EU lawyer, and I'm particularly interested in courts and how courts make decisions. So that's where I will be getting my examples from. And a project that I wanted to speak something of today is the Europa project that I'm a part of, which is really a rather big network of scholars from several disciplines, but mainly law and political science, gathered in doing empirical legal research into courts in the European Union. And what we are in particular trying to establish in this project is a European Court of Justice database, which is modeled on, or at least inspired by, the United States Supreme Court database that perhaps some of you might have heard of or even worked with. So the general idea is to compile a complete database over the entire set of cases, judgments, decisions from the Court of Justice since its inception in the 1950s and up until now. So it's a quite ambitious plan. This database will have several different components. So we will have, I've listed two here. We will have, for instance, the CJA database platform, which contains all the data on decisions delivered by the court from 1952 up until today. So it will cover information on every case, parties, judges, kind of procedure, decision, any sort of data surrounding each and every document. We will also have components which will allow us to look into the issues that are raised and the input by other actors. So we are coding all the interventions by member state governments, by the Commission, and by parties submitted to the court. So it will be possible to compare what did, say, the Austrian government argue in this process, and how did the Court of Justice decide which member states are successful in making their voices heard. We will code parties and their lawyers which actors are mobilizing judicial procedures in the EU and how are they represented? And again, where do we see alliances and which ones are successful? We also have a component on national courts that are interacting with the Court of Justice. And we have, which is the icon I put here on the right, the Court of Justice text corpus. And I thought I would use that and illustrate a little bit of what we're doing. So this is a text corpus, again, of the full text of all Court of Justice decisions. And I will just give you a brief look into that. I thought for local interest, I will take a case as my example, and I chose the Leitner case, which is a case of a police officer here in Tyrol who claimed that the public salary regulations in Austria were discriminatory on the basis of age. So he brought an action against the local original police department, claiming that he should be getting a higher wage. And this case eventually made its way to the Court of Justice. So I thought, let's look into this case and see what we find. So the first thing, when this is put into the CJEU text corpus database, and I should perhaps say this is our website is online, but we're still beta testing the database. So unfortunately, this will be a sneak peek, but it will not be publicly available for another year or two. So the first thing we get a number of case identifiers. We see the date and type of decisions. This is a judgment. It was delivered in May 2019. We see which judges were involved. We see the Advocate General. We see it was decided by the First Chamber. And of course, we can use all these labels to gather quantitative data. So we can find, for instance, all the cases that where Arabadiev was the reporting judge, and so on. And then we get the text of the judgment. And moving into this, we also get this sort of information extracted for each of the paragraphs in the judgment. So I just jumped in here at random. The first two labels here are not so important when we looked at the individual case. It's just a case identifier and the paragraph number. Circled in red here, it says that this section belongs to the grounds of the judgment. And this is something where we are currently working on making this a bit more, fleshing this out a bit more. And when I say we in this instance, I really mean my colleagues, to be perfectly honest. But where we are looking into teaching the computer to identify where we are in the reasoning and identify individual issues that are brought up in the case. So for instance, in this case of Martin Leitner, the referring court has 3 questions. So the Court of Justice reasoning is divided into these 3 questions. And here, as we can see in paragraph 29, the court starts answering the first question. And when we're finished, this label that is circled in red should be saying not only grounds, but should actually in paragraph 29 be saying that, well, this is the start of an argument on a specific legal issue. And then in 30 and 31, we will see that, well, here is the continuation of the reasoning. And eventually we will come to a paragraph where the computer tells us, well, this is the conclusion on this issue. And subsequently, we move on to another issue. And this will allow us to isolate different questions that pop up within the same document and also see how, for instance, citations relate to different issues. What's circled in green here is the citations. We see that here the court cites the directive on equality in employment. If we move to the next slide, here we see another, again, circled in green, citation of Court of Justice cases. So this is also being picked up by the computer, the cases that court referred to. Something else that I think is interesting is what's circled in red here at paragraph 47, where we see that here the court mentions a member state. It mentions the Austrian government who submitted observations into this case. So the Austrian government appeared before the court and gave an argument on how it felt that the court should decide this. Of course, it was a matter of Austrian law, so there was a clear interest. Again, this is something that we're working on. So in the final version, it should not just say Austria here, but we should also be able to see how did the court interact with what the Austrian government put into the discussion. So we will be able to see, did the court agree with the Austrian government? Did it refute an argument brought by the Austrian government? Or, as seems to be the case here, did it just recall that the Austrian government made a certain clarification, provided some information? So we're not quite there, but we're working on it. How then can this be used in legal research? And I will give you just a few examples on how I've been using this kind of data in my recent research project I'm actually just concluding. I called it "As You sow, so shall you reap," with a question mark, thankfully, because the results sort of refuted the proposition. What I was interested in this project was the position of the referring court in the preliminary reference procedure. And I realized that that was Greek to anyone who isn't a lawyer here. So again, I will go into a slight detour on the preliminary reference procedure. So let's again start with our friend Officer Leitner here, who brings his complaint to his employer. It's a very local dispute. As far as I understand this, he brings this to the Landespolizeidirektion, which is, as I understand, a couple of 100 meters from here. When he fails, he brings the case before the Federal Administrative Court. And the Federal Administrative Court notes that, well, even though this is a question of Austrian salary legislation, it's based on the Directive on Equal Treatment. So we need to interpret EU law. And when this question of interpretation of EU law comes up, the Austrian court has the option of sending a question, or in this case, as I said, 3 questions, to the Court of Justice in Luxembourg. The Court of Justice will then hear the reference. It will translate it. It will invite parties like Mr. Leitner, member state governments like the Austrian one, but also all the other member states. Institutions like the Commission will come to the hearing, will present their arguments. And finally, the Court of Justice will deliver what's called a preliminary ruling, that is to say, a judgment, where it will lay out how EU law should be interpreted in this specific context. So it will say that, well, in this case, the Directive on Equal Treatment means that there must be an effective judicial review, even after a number of years, for instance. And on the basis of this information, the national court will then go back to the case before it and decide the question of, in this case, Mr. Leitner's salary. So, what I was interested in here in my research is, where does this leave the national court as a player in the EU legal order? Because we know that the Court of Justice in Luxembourg has been really powerful when it comes to developing union law and really developing the European Union that we have today. And we know that a lot of the cases actually in the European Court of Justice are preliminary references that come from the national courts. So my question was, if the Court of Justice is very powerful, and if it generally acts at the request and on the basis of information that it receives from a national court, does this mean that national courts also have a position of influence where they can steer or guide or nudge the Court of Justice into a certain direction? Now, the overall answer is no, for a variety of reasons that I won't have time to go into, but I will show you a couple of those reasons that were particularly interesting from the perspective of digital methods. So first, when it comes to the references, so what we saw in the judgment about the reference to the Austrian government, where the Court of Justice said that, well, the Austrian government made a certain point here. So I examined that sort of mentions or references to actors that appeared before the court. So if we look at the top row in this table, for instance, which is the referring court, we see that, well, the court refers to the national court that petitioned it between 2 and 2.5 times on average per judgment. And the second row, which is the evaluation, it's close to 0 in both categories. That means that usually it does this neutrally. It doesn't really evaluate one way or the other. It just says that, well, the referring court provided some information. What I did here was I divided the cases into cases where the referring court had stated what answer it liked to hear to the questions. Some referring courts do that. Austrian courts do it very often. Swedish courts barely ever do it. But where a national court says, here are questions, and here's what we think is the right answer, then the Court of Justice might agree with that, or it might disagree with that. So this is the distinction I made here. And of course, it makes perfect sense in the second row that the Court of Justice speaks a little bit more positively about the referring court when it's agreeing with the referring court, and a little bit more negatively, the minus 0.06, when it is disagreeing. Now, what is interesting about this table is what we get at the bottom. So on rows 6 and 6.1, references to member state governments. Because here we see that when the Court of Justice gets a proposal from a national referring court and disagrees with it, it starts referring a lot more to member state governments. So if it's all nice and cozy in agreement with the national court, it doesn't seem to care so much about what the national government is saying. But if it's disagreeing, it starts referring a lot more to the input of the national government. And what's more, if we look at the second bolded row, it starts referring to it much more positively. And there's a similar pattern towards the end with regards to the Commission. We also see a lot more references to the Commission. We don't quite see the same pattern of being more positive, but then again, the Court of Justice almost always is positive to what the Commission says. So that maybe we would not expect. So what the conclusion I draw from this is first that, well, it does seem that the referring national court has a position that is of some importance to the Court of Justice. Otherwise, we wouldn't be seeing a difference between these two columns at all. So the court does react to disagreeing with the national court. And but then on the question of how it reacts, my interpretation of this is that it seems to react by seeking another authority to look to. And specifically, it seems to seek political authority. So it seems to be saying that, well, we have other powerful allies, so we don't need the national court. And perhaps there is even a slight threat built into it that if the national court does not obey, there is a risk of legislative override, either by the national government or at the EU level. And if we connect this all the way back to the normative stance that I was speaking about in legal scholarship, I would say that, well, this is actually a bit of a problem, because from a legal perspective, these are not convincing arguments. This is a sort of faulty appeal to authority. It's an authority that is not legally convincing. I will show you one more example, which has to do with the citations. So remember, we could pick up what the court cited, what legal sources it referred to. And what I've been doing here is that I've compared, on the one hand, the legal sources that a national court refers to when it sends the first request for a preliminary ruling to the Court of Justice. That's the higher light blue staples. The darker blue parts of the staples are the references to legal sources that also recur in the judgment. So the extent to which the national courts and the Court of Justice thinks that the same legal sources are relevant to dispute. And these generally stay around 20% at most. So this shows us that, well, the referring court will bring in its own legal argumentation, but it doesn't seem that that will actually have much of an effect on what the Court of Justice eventually rules. The Court of Justice seems to find its inspirations elsewhere, which again is part of why I conclude that this procedure doesn't really cast national courts as particularly influential players in the preliminary ruling procedure or in the European Union at large. So to sum up, I would like to look a little bit ahead, not only speak about what I have done, but also a little bit on what I would like to do going forward. So what I've been doing and what we are doing a lot in this Europa project is to combine traditional legal insights or methods with this kind of quantitative content analysis based specifically on coding, both hand coding and automatic coding. What I feel, this does give us interesting insights, but what I feel is that we lose a lot of the nuance and detail that is really quite important for legal scholarship. So what I'm interested in going ahead with and look deeper into would be to explore what possibilities there are in the linguistic field for going into computerized methods. I'm thinking particularly natural language processing to explore these judgments. Because you remember I said that law traditionally is really close to the text and really interested in textual detail. And that is what we lose using these kind of coding methods. So again, using the Leitner case just to highlight a few examples of what I think would be really interesting. Say we're interested in what is the importance of the Charter for Fundamental Rights in this sort of cases. And of course, the tools that we have can tell us where the court refers to the Charter, and that's a start. But as lawyers, we would also be interested in how the court refers to the Charter. So, for instance, what's underlined here, we see that here the court refers to some articles in the directive read in conjunction with Article 21. That sort of puts the Article 21 of the Charter, that's the right to non-discrimination, it puts it in a sort of secondary position as an aid to interpretation. If we look a bit further ahead in this judgment, we see that the court moves on here. It refers on the first underlined part here to Article 47, which is the right to a fair trial. And here it refers to Article 47 and Article 9 of the directive. So here it seems to be putting them on a more equal basis. And in the second and third instance here, we see that the court has even switched to referring only to first the obligation of Austrian legislature to respect the fundamental rights guaranteed in Article 47, and then again a reference only to Article 47 as a freestanding obligation. And again, towards the end here, we see that there has been a breach of Article 47 of the Charter in itself, but then in the conclusion, we're back to Article 47 alongside Article 9. So this is the kind of nuance that we're not yet really picking up on just looking at references. That would be really interesting to explore from a language perspective. I think I added another example. Yes, so this is a balance of interest that the court is carrying out. So it says in the beginning, it identifies some interests that is being defended by national law, fiscal neutrality, procedural economy, and so on and so forth. And then the court goes into discussing this. It says first that, well, EU law does not preclude this sort of considerations, but they cannot in themselves constitute a legitimate aim. So they're acceptable considerations, but weak. Secondly, some other considerations are legitimate and they can justify, but only for a transitional period. So stronger, but not strong enough. And finally, we see that, well, they cannot justify a measure that maintains a breach of EU law indefinitely. So again, this is something that we could perhaps, where it would be very interesting to be able to look into this sort of balance of interest, which is really what lawyers are very used to analyzing in an individual case. But it would be really interesting to be able to go into this sort of depth in a more quantitative way. So at that, I will be really interested in hearing your reactions and input. Thank you.
Thank you very much, Anna, for a very fascinating perspective.